Welcome to Epg Pathashala. I am Dr. S. Samba, retired Deputy Director from the Central Leather Research Institute, Chennai. This module deals with information related legislation, particularly with IPR, what they call as intellectual property rights, Right to the Information Act 2005 and censorship, all issues connected with censorship and library information centers. So, first let me give you a small introduction about the need for these things. See, actually libraries and information centers, as you are all aware, are social institutions which are impacted heavily by developments in the social, economic, political and legal milieu of which they form a part. Now, when this happens, not only activities in the libraries and information centers, but also the education and the training of the personnel manning these centers have to be looked into. So, hence the next few modules will deal with this aspect of libraries and information centers. Before I proceed further, I would like to tell you that I am going to use three abbreviations. These are LIC, which refers to a library and information center, LIS, which refers to library and information science or service, and LISP, which relates to library and information service personnel. The first module we are taking up relates to the intellectual property rights, or IPR as it is commonly known. Why are we looking at this basically? Because IPRs have been growing in importance and most library and information centers are also involved in IPR activities, either directly to some extent or indirectly to a large extent. Now, especially with the coming into existence of TRIPS, that is trade related intellectual property rights, about which I will be talking in detail a little later, and its implementation in India. Now, when we think of property, we think of normally two types of conventional properties. One is movable property and the other is the immovable property. The third property, called intellectual property, is now gaining an economic importance. Intellectual property issues, or IPRs as they are known, have been gaining in importance over the past few years, especially with the coming into existence of the TRIPS agreement, of which India is a member. I will talk about the TRIPS later when we look at IPR in detail. Meanwhile, there are two things that you have to bear in mind. One is, when you think of intellectual property, which is just like any other property, that the owner has the right, the freedom to use the property as he or she thinks fit and to exclude others from doing it. Please note that this is a very important point of intellectual property, that you exclude others from doing it first, just like any other property. But the most important point is that there is a time limit specified for ownership. This is what distinguishes this from the other types of property, and this time limit is specified by the state. What exactly is intellectual property? Actually, intellectual property is property that results from the creations of the human mind, the intellect. It can be divided into copyright and related rights on the one hand, and industrial property on the other. Industrial property covers patents, trademarks, designs and geographical indications. Why is there a time limit for intellectual property? This is because two contradictory perspectives have to be taken into account. One is that the individual, the creator of the property, has the right to enjoy the fruits of the intellectual endeavors. So, that is understood. But we also have to bear in mind that society has to benefit from creativity. So, it is because of this, to allow society and humankind to benefit from the creations of the mind, that the time limit is specified, after which it comes into what is called as public domain, so that everybody can use it. Now, we will talk about public domain when we talk in detail when we take up the copyright paper. Categories of intellectual property: these are trademarks and service marks, designs, geographical indications, protection of new plant varieties, layout of design of integrated circuits, patents, copyright and related rights. This module or this lesson material deals with copyright, patents, trademarks, designs and geographical indications alone, and not with plant varieties or integrated circuits. In India, the Controller General of Patents, Designs and Trademarks administers all matters pertaining to patents, designs, trademarks and geographical indications. You will find on the PPT, the URL is given for you to access it and learn more about it. Then copyright is administered by the Copyright Office under the immediate controller of a Registrar of Copyrights under the Ministry of Human Resource Development, Department of Higher Education. Here again the website address, the web address is given. Now we have looked at India. We also need to look at the international scenario. World Intellectual Property Organization or WIPO is a global forum for intellectual property services, policy, information and cooperation. It was established in 1967 to promote the protection of intellectual property throughout the world as a specialized agency of the UN and is headquartered in Geneva. It is responsible for promoting IPRs and basically harmonization of IP related legislations through all the member countries. India is a member of the WIPO, which right now has 186 member states. So you can look at the website, which is again given in all the websites are given in the PPTs and in the lesson modules. Please go through them in detail to get more information. Then we come to the international treaty, TRIPS, about which I mentioned earlier. This is a treaty administered by the World Trade Organization. What it does, it sets minimum standards for intellectual property, which is the standards which have to be followed by the member states. Now, actually, why are we talking about TRIPS? The TRIPS is because it introduced in intellectual property for the first time into the international trading system and looked at intellectual property as an economic resource. So, here again you will find the website. Now that I have told in brief about WIPO and TRIPS and about the Controller General of Patents and Trademarks and Designs and Geographical Indications in India, let us look in detail at each one of the intellectual properties that we have listed. One is patents, second trademarks and service marks, third is industrial designs, fourth is geographical indications, and finally copyright. Now let us look at patents, which are one of the oldest forms of intellectual property. What is a patent? A patent is a protection given to an invention. It's a product or the process of manufacturing that product. It is exclusive right, as I told you, given to the inventor for a specific period of time. What happens is the inventor has the right to make, sell or use the product or the process. As I had mentioned earlier in the introduction to IPR, you have said the rights are given for a specific period of time. That's mainly to because of two fundamental principles, that human effort should be rewarded and that it should not be sole possession of the inventor in perpetuity. The public should also have access to knowledge created by the inventor. The document which describes the invention is called a patent specification. It describes the invention and sets out the scope of protection. But I will be going into detail a little later, because patent specifications being documents, and we as library and information and personnel are really interested in documents per se. So, let me go now to the next one. I have already told you that the two international organizations are WIPO, the World Intellectual Property Organization, and the trade related intellectual property rights are TRIPS. But let us look at some of the international conventions and treaties which deal with patents alone. The Paris Convention for the Protection of Industrial Property was in 1883, is one of the earliest conventions, and as of 2013 it has 175 contracting member countries. India became a member in 1998. Actually, the principal features of these are national treatment, right of priority and common rules. First we looked at Paris Convention for the Protection of Industrial Property. The other one is the European Patent Convention 1973, which is a multilateral treaty instituted by the European Patent Organization for granting European patents. The EPO provides a single patent grant procedure. It is, however, the Euro patent is not a single patent, but a bundle of national patents. Right now there are 38 members. Now let us consider Patent Cooperation Treaty 1970. Actually, we are talking about patents. They are country specific. You file in the National Patent Office for your patent. But we have to, if we want to get patent protection in different countries, we will have to go and file in different countries, and which means an enormous amount of time and expenditure. So, the Patent Cooperation Treaty provides a unified procedure for filing patent applications in each one of its 148 contracting states. File one international patent application under the PCT, you can seek protection and priority in designated countries. India is a member of the PCT from December 1998. Since patents are country specific, when you file it in different countries, you have to deal with different laws. WIPO, to facilitate this, has created an electronic database called WIPO Lex, which provides access to intellectual property laws of the member countries. Not everything can be patented. So, there are criteria for patenting. The three criteria are novelty, non-obviousness and utility. What does it mean? Novelty means the invention must be new or novel. People should not be aware of it earlier. Non-obviousness, there should be an inventive step which should be involved. That is, there should be an inventive step. And utility, that is, it must be capable of application. Before proceeding further, I would like to give you information on many of the terms which are used in patent literature and some of the concepts. So, first thing that we will be taking up, because we mentioned novelty as one of the criteria, the first thing that we will take up is what is called as prior art. Prior art is the total body of knowledge about an invention, a product or a process of manufacture. This need not be restricted to documentary sources of information alone. It could have been demonstrated, it could be traditional knowledge. It's actually prior art is necessary to confirm novelty and non-obviousness. Then we come to what is called as priority date. I mentioned a little about filing date when we are looking at PCT. So, what is priority date? Priority date is the date of first filing allotted by the patent office to any application. The first to file the application gets the priority while granting the patent, and thus ownership of the patent is given to the person who files first. However, this is not the case everywhere. Some countries have what is called as first to invent, like that an example is the United States of America, whereas India follows the first to file criteria. The other concept or term that you should be aware of is inventor and applicant. The inventor need not necessarily be the applicant. The inventor and the owner of the patent may be different. This is because sometimes patents may be invented or processes may be developed as during the course of employment, in which case the employer becomes the applicant and the owner. But this again is not necessarily so in every country. In India it is so, but in United States the inventor alone can be the applicant. Let us look at India in detail. The Patents Act, which came into force in April 72, repealed the earlier act. It did not permit product patents for drugs and pharmaceuticals and certain classes of chemicals. However, the Patent Act 70 was amended in 2005 to bring it in line with the TRIPS requirements and provides for product patents in food, medicines and for other chemical substances. Patents are filed with the Patent Office administered by the Controller General of Patents. The head office is in Calcutta with offices in Delhi, Mumbai and Chennai, and they have defined territorial jurisdictions. So, when we look at the Patent Act 1970, it defines what an invention is. But this has already been spoken about when I mentioned the criteria. So, you can look at the Patent Act yourself and look and find out. Now, not everything, as I told you, can be patented because they have to fulfill certain criteria. But otherwise also, there are many things which cannot be patented or patents are not granted in India. What are they? For instance, things that exist in nature, scientific theories or mathematical models, a method of agriculture or horticulture, traditional knowledge, an invention which makes use of traditional knowledge, inventions related to atomic energy, inventions contrary to law or injurious to public health. I am just mentioning a few. The Patent Act lists all the things which cannot be patented. Patents are being taken for microorganisms. One of the criteria for a patent specification is that it should be written in such a way that a person who is well versed, skilled in the art can perform the invention or carry out the invention. However, when the case of microorganisms, it is not possible to do so. It is not possible to describe the invention in such a way that they can perform the invention, which, as they call it, perform the invention. So, a treaty was signed in Budapest by which these microorganisms are deposited in international depository agencies. India also has depository agencies, and I have listed them here in your slide as well as in the text. And this is a treaty administered by the WIPO, and India became a signatory in 2001. So, library and information science personnel who work in biological laboratories would have to know about this. Now, let us look at some of the procedures for patenting. First, you file a patent application, then the patent office checks for the criteria mentioned and whether all the documents are in order. It also looks at prior art, which I have already explained, and then it publishes the patent document, in its official journal. It is now ready for opposition. If there is no opposition, it is granted or sealed and the ownership is given to the applicant. However, if they find that from prior art that the invention is not novel, the patent will not be granted. The reason why I am repeating this over and over again is searching for literature for prior art is one of the main functions of the library and information science personnel. So, once the patent is granted, the owner has a right to exploit the patent. Now, India allows both pre-grant as well as post-grant opposition. I am mentioning this specifically because I will be repeating it again when I come to patents, the activities of the library and information science personnel in relation to intellectual property rights. Currently, the term of patents in India is 20 years from the date of filing the patent and the complete specification, or the date of filing the patent, because even provisional you can take it. So, currently the term of patents in India is 20 years from the date of filing the specification. It can be renewed every year on the payment of a fee. After the 20-year term, the invention falls into the public domain. There are types of patent applications. We talked about PCT application already, and then patent of addition, in which case you can add some more, or you can divide the patents in case it deals with two different types of, if you want to, and get separate patents. But more than that, let us look at provisional specification. The reason why there is a provisional specification is that you may want to get priority date. So, you file basic details as a provisional specification, and within a stipulated or specified time period, you file the complete specification. And the complete specification has to give the following details. The complete specification is a document containing the detailed description of the invention along with the drawings and claims. The description also has prior art first, and it would be such that the person skilled in the art may be able to perform the invention. The complete specification contains the patent number, title of the invention, the field to which the invention belongs, the patentee, the inventor, the applicant, the name and address and nationalities of the above, and also init codes, the patent classification, both of which I will be talking about later, and claim section. Claim section in the specification defines the scope of legal protection. Now, the reason why I am talking about init codes and IPC, International Patent Classification, is because of their absolute relevance to the library and information science personnel. Two other concepts have to be looked at. One is an equivalent patent and the patent family. The patent family consists of all patents which relate to the same invention published by different patent offices in various countries. Then one more concept which we all have to know about is infringement. What is infringement? Infringement is when somebody other than the patentee exploits the patent. That is, you are violating the exclusive rights of the patentee. As library and information science personnel, we are interested in retrieval tools. So let us look at the various retrieval tools which have been made available for us. One is the Indian patent classification, which is more than 60 years old. All the groups of technology have been classified under 208 classes into 66 groups, which are further subdivided, such as agriculture, which will have a subheading harvesting machinery, but it is not being used now. The reason why I am talking about this is for historical information retrieval. The other is the International Patent Classification, which came into existence because of the Strasbourg Agreement of 1971. It provides for a common classification of patents wherever they have been issued. It is a hierarchical system in which the whole area of technology is divided into sections, classes, groups, subgroups, so on. I have given examples of this in your module. What we have to know about is that the classification is revised annually, and WIPO has brought out a guide to the UPC, which is available on the WIPO's website. So, if you have in order to assign class numbers, we can use the guide for assigning class numbers. Then the other one is the cooperative patent classification, which is a joint partnership between the European Patent Organization and the United States Patent and Trademark Office. The most important retrieval tool is the init code. What is an init code? Since patents can be filed in any country, they will be in different languages, and there will be differences in terminology to describe the various data elements. To overcome this, init codes have been developed as a common code for identifying the bibliographic and other data elements. These codes were standardized by the International Cooperation in Information Retrieval among Patent Offices, ISRIPAT, which ceased to exist in 1971, but its functions have been transferred to the WIPO. INIT actually stands for Internationally Agreed Numbers for the Identification of Bibliographic Data. There are numerals and are language independent. I will just give you two examples. For instance, 11 stands for patent number, 57 stands for abstract. One more example is that 54 would be a title of invention. These codes can be used in the creation of in-house databases. Now, let us go to sources of information. Patents have their own terminology, but which we have to be aware. The OECD has brought out a glossary of patent terminology. The other retrieval systems that we can look at information sources is the iPairs, which is a free search portal launched by the Indian Patent Office. The official journal of the Patent Office is available on its website, and it replaces earlier journals and the Gazette of India Part 3 Section 2. It is a weekly publication and gives notices of patents filed, granted, and opposition proceedings, and so on. Priority document, prior art details, everything that you want to know about Indian patent. The Office of the Controller General of Patents is also bringing out, since September 2014, a journal called E-Patrika, they called it, titled IP Expressions. The first issue has just come out. Then one of the mandates of the WIPO is to offer technical assistance to developing countries. Therefore, WIPO has set up a WIPO Patent Information Services for handling requests from developing countries free of charge. That is called the WPIS. I will reiterate again, all details are given not only in the module, but all the websites have also been listed. There is a WIPO Guide to Patent Information, which is useful for understanding the structure of a patent document, and it provides tips for searching them. WIPO has also brought out a guide to technology databases to assist users in identifying and using online databases relating to patents. This guide has been described in the module, and it covers both commercial and non-commercial databases. In addition to this, there is what is called as the Intologist website, Patent Lens, which gives access to free full text patent databases, Google Patents, Patent Scope, which also has translation stores, Patent Scopes, which has translation tools in 9 languages. All these information sources have been described briefly in the module, but the websites have been given. So, you can go to the websites and learn about these information sources. They are very useful for searching patent literature. In addition, websites of national patent offices have access to their own patent databases, such as the USPTO. I have already mentioned India, the British Patent Office, and so on. The other patent database which is of real use to us will be the one developed by the SpaceNet, which is the European Patent Organization, which also deals with PCT patents and in detail, and which also has a global patent index. The INPADoc provides information about patent families, which I just mentioned briefly earlier. I would like to reiterate once again that novelty is one of the criteria for patenting. Now, novelty is obtained by going through prior art, information on that. However, novelty is not restricted to recent patent information alone, but also historical information. So, I am now going into the historical sources of patent information. So, let me start with a brief sketch of some of these sources. First will be the Gazette of India Part 3 Section 2, which was a weekly publication brought out by the Controller General of Patents and gave all information about patent applications, patents granted, and so on. The other is Patents for Inventions, Abridgments of Specification. The scanned versions of these volumes are available in the archive.org website. These are published in 1800s. They cover British patents from 1660 onwards. We have Patents for Inventions, Abridgments in India also, where they were issued in 66 fascicules, and each one corresponded to one group of the Indian patent classification. Then we had the Patent Office Journal from 1912 to 1960. Then indexes were brought out by the Patent Office covering the years 59 to 64, 68 and 69, which covered the subject matter index, reference index, chronological indexes, and so on. Then you had the Journal of the Patent Office Technical Society, which was published in the 60s. Then you have the Patented Inventions of the CSIR 1940 to 1964. Then you have the Impact Database, a product of NISCARE, where it contains bibliographic information on more than 50,000 patents granted between 75 to 2002. The other databases are the ECASWA A and ECASWA B databases, which were brought out by the Patent Facilitating Center of Technology Information Forecasting and Assessment Council, the TIFAC. Now, you have the ECASWA C, which is recent, which is takes care of recent applications. I have spoken about electronic and printed sources of information. I will just mention a little of the institutional sources. The website of the Controller General of Patents, Designs and Trademarks gives information on all aspects of patents. Then you have the Rajiv Gandhi National Institute for Intellectual Property and Management under the Ministry of Commerce and Industry. Then the Patent Information System established in Nagpur in 1980. Now let us look at the role of information personnel vis-a-vis patents. Novelty means that information should not have been published elsewhere, there should have been no oral description or demonstration, or it should not be traditional knowledge. So the library and information science personnel can help the patentee in two ways. First, in creating an awareness of the need for novelty so that their patents are not rejected. 1. 2. In searching for novelty, in searching for information which will negate novelty. So that is why all the information sources about patents have been described to you earlier, so that it is easy for you to go and conduct searches and tell them that such a thing is. It's not only patent literature but other literature also, but I mentioned patent literature because this module deals with patents. The reason is there is a vast amount of technical information available in patent literature. According to WIPO statistics, there was a growth of 9% of patents with 2.5 million patent applications worldwide and a 9.4 million patents being in force in 2013. So you can imagine the vast store of technical information that is available and which has to be tapped by the information personnel. The library and information science personnel can help in documenting traditional knowledge in areas in which the organization is involved. In this context, they should be aware of the Traditional Knowledge Digital Library, a project of the Lis Ks. This has been described in detail in the module, as well as the incidents in which patents have been overturned because of information obtained by scanning through traditional literature. The other one is in creating in-house databases for which they could use init codes and the IPC classifications to facilitate portability. The final thing is, this is not for helping the organization, it is for a sort of self-education and self-enhancement of the profile of the library and information science personnel itself. That is by looking at the citation pattern of patent literature, which is purely falls within the expertise of the library and information science personnel. So far, we have been discussing patents, patent information, need for knowing about patent information. So let us go to the other types of industrial property, but this I will be dealing with only very briefly. They are trademarks and service marks, industrial designs and geographical indications. A trademark is a visual symbol used to label goods or services so as to distinguish the goods and services of one undertaking from the goods and services of another. A service mark is used in the service sector, such as the hospitality sector, the education sector or the hospital sector. So let us look at both of them a little in detail. These marks can be a name, a word, a symbol or even a combination of the above. Trademarks are administered by the Trademarks Registry under the Controller General of Patents, Trademarks and Designs. The head office is in Mumbai with offices in Kolkata, Delhi, Ahmedabad and Chennai. It administers the Trademarks Act of 1999 and with subsequent rules. Registration of trademark is not compulsory. However, it would be useful when you deal with cases of infringement. I have already mentioned what infringement is. The registration of a trademark is for 10 years and it can be renewed. Let us look at the information sources. The Trademark Journal gives details of the trademark registry, that is the trademarks applied for, renewed and so on. The database, there is a database for search, online database for searching trademarks. All this is given in your module and your PowerPoint presentation. There are international treaties for trademarks as for patents. This is known as the Madrid Protocol. The database for searching international trademark registrations is the Madrid Express, and the Romarin database gives details of international marks. Specific init codes are available for trademarks, are called as standard ST60. There is a classification separately for trademarks, that is the NIS classification, which is an international classification of goods and services and contains 45 classes, and they can be used for retrieval purposes. The other classification system is the Vienna classification, which is established under the Vienna Agreement. The second category that we are going to look at now is the industrial designs. It relates to the ornamental or aesthetic aspect of a product, useful product. It is concerned with the shape, texture, color, configuration and pattern, or a combination of these. What it does, it protects the appearance of a product. The Indian Design Act of 1911 has been replaced by the New Designs Act of 2000. As for patents, novelty is a criterion for industrial designs also. The duration is for 10 years, which can be extended on the payment of a fee. Let us look at the information sources. The part 2 or part 3 of the official journal of the Patent Office, which was mentioned earlier under patents, covers all information relating to industrial designs. Then you come to design application status, can be ascertained by searching the Indian Design Application Retrieval System, the website of which is given in your module. There is an international treaty for designs, which is called the Hague system, and there is an online database called the Hague Express, which is used for the international registration of designs. There is a separate classification for designs called the Locarno classification. India uses this classification for classifying designs. Before proceeding to copyright, we look at another category of industrial property, which is the geographical indication. What is geographical indication? It is a notice stating that a given product originates in a given geographical area. It is called GI for short. It is used to identify goods having special characteristics because it originates from that area. It is important because we associate certain qualities with those products and a reputation to the product. The registration of GI gives the party registering the GI and its authorized users the legal right to make exclusive use of the GI, and as in the case of other intellectual properties, exclude others from using it. It helps in promoting trade and commerce for the regional product and in preventing unfair competition. India enacted the Geographical Indication of Goods Registration and Protection Act in 1999, and it came into force in September 2003. The registration is valid for 10 years but can be renewed indefinitely. The Act is administered by the Controller General of Patents, Trademarks and Designs, who is also the Registrar of Geographical Indications. The head office is in Chennai. You will be interested to know that Darjeeling tea was the first product to get GI tag in India. GI registrations have been given for many items such as Mysore silk, Dharwad peda, Tirupati laddu, Bhavani Jamakalam, AI leather and so on. So, I mean, if you go through the website, you will find the list of GI tags which have been given over the years. The journal or the information for GI can be obtained by going through the Controller General of Patents website. The international agreement for GI is the Lisbon Agreement, and international registrations can be searched using the Lisbon Express. Appellate of origin is a special category of GI, but in the appellate of origin, there is a closer link between the place of origin and the product. The reason is the product and the process of manufacture should be done at the same place, which is not necessarily so for GI. So far, Under the module information related legislation, we have looked at intellectual property rights, that is patents, trademarks and service marks, industrial designs, geographical indications and copyright. We have looked at their definitions, descriptions, the international treaties, the Indian scenario, and how it affects the activities of the library and information centers. Thank you.